to do that. Okay. So, what can be instances that you need to understand in special complex crimes? Yeah. What are examples of special complex crimes? As I mentioned, there are instances such as rape with homicide. Rape with homicide is punishable under Article 266-B. So usually it is indicating that the major offense would be the killing of that individual. But it so happens that, well, rape was commenced or committed, then there can be a consequence to such commission. Okay. Let's go now to your different circumstance. I wanted to emphasize on our discussion for unlawful aggression. Here are the summary of the notes that you need to know with respect to justifying circumstances. Here. This part. So please be mindful. You have to memorize the elements under justifying circumstances. This includes already your unlawful aggression, your unreasonable necessity of the means employed to prevent or repel it, and then the lack of sufficient provocation on the part of the person defending himself. By this reason, we are already tackling modifications, because when you're going to look into exempting circumstance, mitigating circumstance, there are incomplete self-defenses. So you might as well know and have the criteria for knowing how to understand the elements for self-defense. So part of the book here is that it states that unlawful aggression means that there ought to be a peril on one's life, limb, or right, whether it is either actual or imminent. So the consideration here is for you to know what is actual, wherein the danger is actually being present or existing, imminent, or it is at the point of happening, or by the simple definition, it is something that is to be expected of. Okay? So it is not required that the attack has already begun, but you can state that it might be in the point of or possible for the realization. Now, some of the discussions in the book, a slap on the face is already considered as unlawful aggression. The discussion in your annotation states that the face is the representation of your dignity. So slapping you is already unlawful aggression. Gahana pa lang, the attorney, do islap niya lang ko. Then it might fall into what we call as an imminent unlawful aggression. Okay? Pero you need to qualify that, because there are instances wherein the Supreme Court has very consistently upheld that you have to look into the logical sequence of the act and the movement. So medyo very descriptive siya. Now, a strong retaliation of an injury or threat may amount to an unlawful aggression. So the aggression did start from you, maybe, or did start from somebody else, but you did not take part on it. So somebody tried to react or respond, and their response may be considered as that unlawful aggression already. Killing of the deceased by the defendant, may it be simultaneous with the attack made by the one who is the killer, or at least both acts succeed each other without appreciable interval of time. So time is actually a very important element to be considered when you're identifying unlawful aggression, And at the same time, reasonable necessity also would require an interval of time. So the accused may have no time or occasion for deliberation and cool thinking. A public officer exceeding his authority may become an unlawful aggressor. So very dominant during the period wherein the threat, even if you're trying to say that in justifying circumstance, the exercise of a lawful order, particular police officer is already using excessive force, then it may be considered as unlawful aggression. Mayara na siya examples nga ikaw nakita mo ang imo nga brother is being dragged by someone. Unknown to you, that person was already exercising his police power by arresting your brother because your brother committed or did something. So on your part, what you would usually do is you would go to the defense of your relative, which is actually the second part of the requirement of self-defense. But ang pinaka-prominent under self-defense is that the threat should be one-on-one, but that's not the hard and fast rule. So the threat is usually persistent and existing over you. And for you to justify this, take note that you must not be a person who's initiating anything. Okay, well, the story then changes if you are someone who actually provoked, or if you provoked, ladies and gentlemen, your provocation should not be sufficient. Okay? Okay, the wording here is lack of sufficient provocation. When you're stating lack of sufficient provocation, provocation may be allowed, but it may not be as one where it merits your life, or it may not merit the taking of the life of another. Okay? So when aggressor flees, here, there's a instance. When the aggressor flees, unlawful aggression no longer exists, meaning there's already a cut-off point. There's already that interval that the other will not be any more an imminent or an actual threat to you. However, if the purpose of the retreat was for the aggressor to take more advantageous position to ensure that his attack will be more successful, then you can mention that unlawful aggression is still present and imminent. Okay? So when you are trying to pursue laot mo, you then realize that the attack, the one that you're eventually going to kill, that unlawful aggressor, is someone that has secured his position for the success of the commission of a felony, then you are still justified to use self-defense. So no unlawful aggression when one is agreed or has agreed that this is going to be a fight. So in instances wherein both of you entered into an agreement to duel, you cannot claim he is the unlawful aggressor because both of you are at some point and in one point unlawful aggressors to each other. Okay? Pero there is an exception here. However, if the aggression that you're talking about speaks more primarily on an instance wherein you or another person went ahead. What do you mean by that? The aggressor or this other individual already went ahead and attacked you before your designated place and time, then you could claim that he has already breached his kumbaga, the terms of your duel. So it can be an unlawful aggression. Now, mere threatening or intimidating attitude, dubagsik, siga, not preceded by any untoward material aggression, meaning there's no physical, there's no, it's not coupled with an invasive act or inflicting act, then it cannot be considered as an unlawful aggression. Okay? Because it is required that there is some offensive and positively strong showing of his intent to cause injury towards you. Okay? So a person defending himself cannot be expected to think clearly as to control his blow. So there are instances, again, what the reason for the unlawful aggression or self-defense in general is that you might not know the level of your strength that you're applying. Okay? Kasi at the height of the squabble and all of that, there might be instances wherein you have used the force excessively just for the adrenaline of it. So technically, the law favors, again, the one who is defending himself by reason and cause, that you might not know and control your own strength. So the measure of rational necessity, this is to be found in every situation. And it would be varying to how much and to what level are you exercising the restraint or the repelling part. Okay, so here, whether the means employed is reasonable, it will all depend upon, first, the nature and quality of the weapons used by the aggressor. So if an aggressor comes up to you and he is pointing to you, say for instance, brandishing a dagger or a knife, and for you, your self-defense is to immediately consider a bazooka. Ikaw ha, unlawful aggression ka, palukpan mo sa dayon, and then he blew him into smithereens, like in tiny little pieces. Therefore, there can be the violation of the second criteria of as to the rational or reasonable necessity for its kumbaga disparity between the attack and what is being used and utilized to repel it. Now, rational equivalence is actually born out of the circumstance. Say for instance, gingamit niya knife. So, ang mga example na di usually ginahatag, if you've seen movies and fight scenes of Jackie Chan wherein he uses ordinary things or object to repel that kind of attack, an ordinary ladder, chair or a table, even an umbrella would be those instances where there's a rational equivalence of it, simply because you would not want to be inflicted with harm or a victim of the injury. Now, another criteria that you may need to consider is physical condition, the character, the size, and the circumstance of those affecting. Imagine you going to court, you claiming that you repelled an unlawful aggressor. The aggressor is actually half your size, half your weight, and all of that. So, but then what did you use? You used a gun to kill that person, or you used a big bolo to strike him in the head. And ang rule of thumb gid actually that day is that you do not take away the life as an automatic recourse to repel the aggression. You just simply need to prevent that person from continuing with the act of inflicting injury towards you. So, amo na ding ginabalanses ang law nga kung ging-take away mo ang life, ang pagpatay mo sa ina nga tawo will have to be measured onto what are the circumstance, what is the nature, the quality, the conditions involved, and even how and in what manner did the aggression started. Okay, of course, you wouldn't want to inflict or harm another if that person is not a threat to you. So this is the same concept that we're trying to understand, because technically you are posing self-defense by reason that you have already taken away the life of that other person. Okay? And in some instances, kung wala yan napatay, well and good. So you have to be very keen and at least be aware of how you're able to, should I say, assess the aggression, the reasonable necessity, and at the same time, whether or not ikaw gid man bala or somebody else has initiated the provocation. Okay? Sige, let me finish first. If the provocation by the person defending himself is not the proximate and immediate to the aggression, then technically self-defense is actually present. So, important ha, ang provocation, the provocation is one that did not originate from you, or you are not the proximate reason of that provocation, then self-defense could be validly be assailed or utilized. Yes, Archel?
Attorneys, question ng tani bala, if the person that showed aggression to you is a disabled person, for example, are you allowed to do a self-defense? I
Depende
mean
kung
kay
depende kung ano nga klaseng disabled yung tao. Say for instance, he has full mental capacity and mas dako pa siya sa lawas kaysa sa imo, bodybuilder pa siya, pero ang iyang defect is that libat lang siya or wala siya, isa lang iyang mata or may speech impediment siya, then you also have to look into the characteristics and the physical attributes of that person. So pero hindi man na meaning kung may ga-attack sa inyo nga ara sa wheelchair or hindi na ko kay ano niya siya tawag, may disparity sang reasonable necessity. Again, you would have to look into the very, very basic character na when somebody is a threat or is already becoming or exercising unlawful aggression, you have to bear in mind that self-preservation is the ultimate reason why you are trying to defend yourself. So, ni PWD man na or hindi, since that person has already exercised unlawful aggression against you, then you could validly and legitimately utilize repelling it. And in the course of repelling it, you might have killed him in the process. So medyo amo na siya ang angle for self-defense. Okay? Now, defense of the relative is the second requisite that you have to understand. So anyone who acts in defense of the person or the rights of his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites are prescribed or present in this case, and further, that in case there was provocation, it was given by the person attacked, the one who is making the defense did not take part in the provocation. Okay? So the provocation must be, because you're entering into a picture here. Una, one-on-one, ikaw lang kag ang unlawful aggressor. And this in this scene, there are one person and another person, and then you come into the picture. We're dealing with the point of view of you as the relative who is trying to come into the defense or rescue that relative. So there are specific criteria. It must be within the fourth civil degree. So attorney, what if hindi siya masulod? Then it's no longer defense of a relative, but it's a defense of a stranger, which is the third part of the justifying circumstance. Basta just remember, ang unlawful aggression is a necessary gidyang condition for justifying circumstance sa defense. Okay? It again contemplates that there is actual or sudden unexpected attack. And in doing so, there creates an imminent danger. So you have to take note that it's not just mere light threats or just an intimidating attitude. Again, the intimidating attitude, mga ampo lang na, but without, say for instance, a corresponding reason nga flickering or flexing sa inyo nga generation, do ka man handog flex lang wala. Pero ang gina-flex niya, may ara siya bolo sa likod, may samurai siya nga dala, may some other weapon siya nga that he has access to, then it can be a justification on his part. So I'll come back to you. So in the defense of a relative, please understand that unlawful aggression, reasonable necessity of the means employed are still there. And the last part is that in self-defense, you lack sufficient provocation. But in the defense of a relative, you did not take part in the provocation because the law recognizes that it might have been your relative who has been provoking the other to create that situation wherein unlawful aggression is being given. Yes, Miguel?
So, attorney, for example, like ang imob na attorney nga, let's say, bata, may nag-provoke sa iya nga gin-provoke siya sa classmate niya, kito gibuno siya sa lapis, tapos ikaw yun tapos napatay mo yun ang classmate niya, attorney. Does that qualify kay tungod nga bata pa sila or ano, attorney? Ano ang circumstance na?
Liwat ang yung mga problem.
Like, for example, bata mo, no? May ginbuno siya sa classmate niya sa lapis. Mga ang age ni mga grade 3, 12 years, mga 9 years old na, tapos pinatay mo yun ng classmate niya ito nga binuno yung bata mo sa lapis. Does that qualify as unlawful aggression? Or kitungod bata sila sa gidagapon ang ginubra mo?
Okay. So we ought to know also that in justifying circumstances, there are, in relation to justifying circumstance, you have to understand who are exempted from criminal liability. Technically, unlawful aggression by its physical form is, kumbaga, a means or a requisite for self-defense. But you have to look into the juvenile justice law that children below 12 years of age do not commit or incur criminal liability. So for instance, if you are 9 years old and below, ging-igo niya na sa imo, and you ging-igo niya ang bata mo, and then you so happen to kill that child, take note that the origin of the action is that to the child, he does not comprehend in his mind criminal intent yet. That's the presumption of the law. So kung patay mo siya and then provide mo lang sakit niya ang bata ko, one, it may not fall or justify into the criteria of unlawful aggression because the child may be exercising what we call as a neutral act, or something that is not yet considered as an unlawful aggression. Number two, may violation naman na dayon sa reasonable necessity because ging exercise mo yung ultimate nga act of killing the child, which hindi siya commensurate, that would be the term, for repelling the attack. That would now be a motivation for revenge. Please take note nga ang purpose again for justifying circumstance is to prevent the attack. In the example given by Miguel, there was already an attack given, and in the attack that was given, you have to understand that kumbaga na-conclude na ang unlawful aggression if there is. So for his part, ang aton gidyang objective is to make sure that no injury should continue. That's why ang premise ng justifying circumstance on self-defense is that i-repel mo lang gidya ang attack. And in the process of repelling the attack, napatay mo ang ina nga tao, then you are justified. In that example that was given earlier, then I could say na it may not fall into a justifying circumstance by reason that, again, it might not be commensurate, or the reasonableness of such action of killing right away may not be the best solution. Pero may instances na bilang what if attorney ging na continue niya, ginakuga niya ang bata ko. So nakita ko, nagsaka ko sa kwarto, ang akon niya 8-year-old child, ginakuga sang iya nga playmate. And then sang nakita ko, ginglampusan ko siya. Paglampos ko sa ulo. Ang nalampos ko sa iya, abi ko, ulunan. Kay gali, tig-ang flower vase, pack. And then eventually, the child bled, died. Then there can be arguments of justifying circumstance as to defense of a relative. Okay? Pwede siya so long as it fits again into the category and criteria of reasonableness. It fits into the criteria of the unlawful aggression. And base sa amo nga circumstance, wala ka kabalo, ang bata mo ya ang nanunlog sa iya nga classmate. Nga, pisot, hindi ka kabalo mag-drawing. Amo na. There is provocation there. So it should not be within the part of the parent or anyone or the relative exercising the, kumbaga, the defense to be the aggressor in this part. Okay? All right. So I want also you to understand the concept of an absolutory clause. Okay? An absolutory clause is found under Article 332 of your revised penal code. Generally speaking, when you commit a felony against this other individual, you will not incur criminal liability. Okay? Actually, this discussion should be falling into exempting circumstance. But an absolutory clause is one for purposes here, the relationship by affinity created between husband and the blood relatives of the wife, this dissolves by the death of the spouse, thus ending the marriage which created the relationship by the affinity. So actually, kung wala na ang imong this is talking about the instance of ang ginadipensahan mo is ang pakaisa sang imong wife. But patay ng imong wife, then technically it's no longer part of the consideration nga relative mo siya. But the discussion actually in absolutory clause is that the following crimes: theft, pagpangawat, estafa, pagpanginto nga may dala sang kuha sang mga butang, malicious mischief, nature niya is usually you've inflicted some dubious and wrongful machinations. It limits the responsibility of the offender to only a civil liability, and there is no criminal liability here. So sa balay ninyo, mangawat ka sa imong parents, technically, your parents will not be able to pursue theft cases against you by reason of your defense under 332 or your absolutory clauses. Why? Hindi kuman ka mo gina-discourage kung mangawat ka mo sa parents nyo. But again, the law intends to protect the harmonious relationship of the family. And in some case, in instance, may category na kag qualification that you should live within the same household. Okay, that's very important. So this is more of like an adoption from the American legal system where we are talking about two views. First one is that the relationship between and affinities terminate with the dissolution of marriage either by death or divorce gives rise to the relationship and affinity. An exception to this is when the view is that the relationship by affinity continues even after the death of the spouse when there is a surviving issue. Ang second one is that continuing ang affinity maintains that the relationship by affinity between the surviving spouse and the kindred of the deceased person continues even after the death of the deceased spouse. So we hold that the second view is more inconsistent with the language here under our fundamental principle of in dubio pro reo. I forgot to discuss actually general principles of criminal law, But in dubio pro reo means to say that it is in favor of the accused in cases there is doubt. So in dubio, in case of doubt, pro, benefit, reo is the criminal. So in case that there is doubt as to anything that occurs, then it is to be judged in favor of the accused or the criminal. Okay? Now, here, the third part is the defense of strangers. So anyone who acts in defense of a person or rights of a stranger, provided that the first and second requisite mentioned in the first paragraph is that present, and the third qualification is that the person defending be not induced by revenge, resentment, or other evil motive. So in instances nga napatay mo ang tao, nga gina-repel mo ang pag-attack sa isa ka tao na hindi mo man kilala or technically hindi mo parente, kung napatay mo siya sa ina nga proseso, again, you look into the unlawful aggression, the reasonable necessity, pero mas importante ginadi ang third nga wala kaya na motivate nga wala kaya na motivate nga patyon siya, or because kabalo ka may history ka mo, daman mo lang patyon tagay ka meg because amo ni siyang amo ni gina avoid sang lay. The loophole is that you are going to assign someone to be the one who is going to provoke. So si Vincent, nainit siya, say for instance sa akon, gingsugo niya si Archel, garit-garit tatog lang sir doors. So ako, naging garit-garit niya ko, doon nainit ako, and then at some point, nagtapungulay kami ni Archel and all, and then nakita ni Vincent nga, ari ay chance ako na ni balo, santa ni si sir, kay kagamay sang grade naging hatag mo sa akon, ari mo ay, boom. So, here, even if you say that there is unlawful aggression that I am causing, and there might be reasonable necessity nga ging-employ ni Vincent, say for instance, ginglampusan niya ko with some other material or some other source, but he was induced by a certain revenge or resentment, then he will not be able to fully enjoy and avail of the reasonableness of defense of a stranger. So amo ni siya, kung if you get to be in a practice, you get to be in the legal field, you only need to establish that anong history nyo, mayo ang personal relationship nyo. Did it occur that as a fact nga nagpabarangay na kamo sang una, nag-inaway na kamo? So establish mo lang yun nga may evil motive or my history of resentment, then one will not be able to avail of the benefits of a justifying circumstance. The fourth issuance of justifying circumstance is the fulfillment of a duty. Here, any person who acts in the fulfillment of a duty or is basing his action coming from a lawful exercise of a right or of the office, then you are defended and justified to conduct your affairs in your activity. So the requirements is that you are acting within the performance of a duty. So a duty may be coming from these law enforcers who are trying to simply enforce the law in its raw sense, or when you are simply exercising your right, the right to what? The right to enjoy your property, the right to possess my own property. So that could be a very issuance of the first requisite. And then the second one is that you caused injury or offense as a necessary consequence of what we call the performance of your lawful exercise of right or an office. So here, there's an example, the case of Kabanlig versus Sandigan Bayan. Self-defense and fulfillment of a duty operate on different principles. Ang self-defense is based on the principle of, again, self-preservation. You preserve yourself coming that there is mortal harm to you. While when you are exercising or invoking fulfillment of a duty, it is premised on there is due performance or duty. The difference between the two justifying circumstance is clear as the prerequisite of self-defense and fulfillment of duty. So, an issue here is when a policeman in the performance of his duty is justified using such force as is reasonably necessary to what? Why is he using force? To secure and detain an offender and overcome his resistance and prevent his escape, prevent his recapture, or fulfilling his duty to recapture someone who has escaped, protect himself from bodily harm. This is the full context of fulfillment of a duty. But unlike in self-defense, where unlawful aggression is a fundamental element, it needs to exist. Okay? So in the performance of duty, unlawful aggression from the victim is not a prerequisite. Okay? So here, hapos na niya if you're trying to defend the operations of a police officer in his conduct. May ginada siya instances that police officers would simply impose their duty or impose themselves to other people, claiming that it is in the performance of their duty. So medyo tricky siya. Kaya there were instances wherein they are not on active duty. May pa na siya iban sa mga cases that they are already considering na the issue here is that police officers must presently and validly be exercising an official function or official duty. And that duty must be duly recognized. So, duty to issue a warning is not absolutely mandated at all times and at all costs, at the detriment of law enforcer's life. Okay? So, the directive here is that hindi kinanglan mag-issue warning in several options because again, drill ka lang nakakita kisa sa mga tao, sa mga Pinoy nga huwag kang kikilos, tanan nagdalalagan. Duka ano gid man bala kung Squid Game paniging tiro na sila. So ang isa ginada sa issue that we're trying to signify is that well, we're indicating that there must be an identification of what is that performance and is that performance related to the duty. Okay? So in instances, lawful exercise naman niya, it may be coming from an ordinary citizen simply exercising, say for instance, your right to what? Your right to drive. Ga-drive ka lang, simple and all. Wala ka man ga-exceed sa speed limit. Cautious ka man, nakago man ang signal mo. And then, eventually, may naipit ka, kayang naipit sito, tangadal. O wala, observe or aware sa iyang surrounding. Can you say that in the essence, you are at fault? You can always provide the justifying circumstance na I do not incur criminal liability because I was acting and exercising my fundamental right, which is exercised in diligence. Although you're exercising a right, it has to be coupled with the diligence. Okay, of course, you understand that when there is negligence in the form of it, there is now what we call quasi-delict. You can be held liable because and for the reason of your negligence. But if you're performing something with all diligence within your right, then that is your primary defense against anyone who is going to invoke and accuse you of something that you are not, or to become or held liable. Now, the fifth one is avoidance of a greater evil. So any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. So I want you to understand that this instance observes this act. First, that the evil sought to be avoided actually exists, and that the injury feared be greater than that done to avoid it. Here, there is a different criteria when you're talking about the unlawful aggression, because in unlawful aggression, imminent danger is still qualified. But evil sought to be avoided must be one that actually persists and exists. So if this evil that sought to be avoided is existing, you would want to ensure that it should not continue, then by all means, the reason is that you can employ a certain conduct so that you will now prevent the injury from happening. Okay? That there be no other practical and less harmful means of preventing it. So the greater evil should not be brought about by the negligence or imprudence of the actor, and only criminal liability is excused but not civil liability. A few examples in your book, in the state of necessity, or what we call avoidance of greater danger, is that in here, what is being material is, say for instance, the evil that is sought to be avoided is the perishing or the burning of the house. In the burning of the house, garaya ang tanan nga balay, ang imo nga balay ang madason na nga kanon sang kalayo. So what you did, you cut off the series or the one house that is actually going to devour that house, and then next would be your house. So just like the state of necessity, the injury feared is greater. The greater is that malapta pagid ang kalayo. And if malapta pa ang kalayo, then would it mean to say that you are justified in trying to destroy the house so that hindi mo can be, so long as you can present the logic that there is no other practical and less harmful means of preventing it. So say for instance, palayo lang ha, in America, there are instances wherein there are mass shooters. So the mass shooter is a student. He brings with him an M16, indiscriminately fires at anyone who moves, duwabilog, and then maniro lang siya. And then there are a lot of people already on the ground, dead, lifeless and all. And you happen to be there. You were able to see a firearm on the ground, and on the ground, you would see that the firearm is loaded. You took the gun and you aimed at that indiscriminate shooter. You hit him in the head and he died. Could you claim that you have been justified in using and utilizing the killing of that person? Well, the answer could be possibly yes. Because if you would allow him to continue, greater would be the death that he would be causing. And therefore, for you, it would be more prudent, or in the sense, practical, for him to die rather than killing more and other people. Okay? But please take note, this only extinguishes your criminal liability. Civil liability may still continue and exist by reason that you may need to pay for burial expenses and all other concerns. Same man sa balay. When the house that you destroyed to prevent the spread of the fire, all those who benefited will have to contribute and made an assessment for the payment of the cost of such property. So the last one for us to consider under justifying circumstance is any person who acts in the obedience of an order issued by a superior for lawful purpose. So more or less, this is not just limited to what you call this law enforcement individuals, but even to an employer and an employee. Okay, So there is actually an order, and the order is actually issued by the superior, or the one that is supervising or exercising authority over you. Then you have to understand that the order is for a lawful purpose. And in that lawful purpose, the means that you have used must be one that is also useful. Okay? Because the instance why this is being written is you might not be acting under your own volition, but you are simply following the order of that superior. But take note, the criteria here is that the order is actually issued and it is for a lawful purpose, and what you are doing is actually lawful, then you are justified in the consequence of any of your act. So here, because there is a superior, there is also a subordinate. The subordinate is not liable to carrying out an illegal order. So this is your defense. You asking your boss, boss is telling you change the date of the expiry of the face shield so that we can still deliver them. Technically, you will be held liable because you are following an illegal order. Okay? But there can be instances wherein you are not fully aware that the order is actually illegal. So, you would be then be considered as one who is justified in following the order of another person, because you do not have that criminal mind in you to commit a felony or an offense. But the question is, if one is aware, here the example is if you are not aware of the illegality and you are not negligent, then you cannot be held liable. Okay? Because, well, judging from reality, ang mga subordinate usually ginasugo lang, not realizing that what they're doing is actually wrong. So, might be a defense that you are obeying simply a lawful order. May ara tabi cases wherein ging-follow niya is an unlawful order on its face. Ano ni siya nga case na lipat ko. But ara ba lang, there was a demolition, and then in this demolition, there were armed gunmen who were there to enforce the demolition. And then there were a picket of individuals preventing the demolition, and they were already having a conversation with the manager there, stating that we have a court order that delays or prevents you from enforcing the what you call the demolition. And in so doing, in so doing, the manager said sa mga tinawo niya, oh, ligpit nyo na yan. And what happened was, the one who were bringing guns discharged his firearm to the picketers. And then it so happened that nangakig daw ng manager, nga, aging ligpit nyo sila. Ang hambal ko, iligpit nyo na yan. Ang mga yan ng ginamin ko is ang mga truck, ang mga, ano ni siya, bulldozer, hindi ang ina ng mga tao. So that was the defense used by the manager, because he is claiming that the lawful order he meant was ambiguous lagid for the most part. Pero do ka, you know, though hindi ka man magpati, you also have to consider the tone, the actuations, and the part. And so that can be a cause of very much concern. Anyway, so judging from that, the next circumstance, I'll share this to you because this is also nice. Wala ko pa rin na-share ito sa inyong Facebook. Exempting circumstance. Here, in exempting circumstance, you need to understand the different characteristics. Under exempting circumstance, the law will not consider anyone here as one where criminal liability can be incurred. Why? Because the requirement is that you need to have a criminal mind. Technically, within its mind, the following individuals here do not possess the mental faculties to understand and appreciate the consequences of their action. So, example, an imbecile or an insane person. This individual may have committed, muna bala, may mga buang na bala sa dalan, nga mga haboy lang sang bato, maigo sa lakyan mo, way kagikwaon. Kay man, technically, they have no criminal liability. But in some instances, criminal liability, civil liability may arise from this. However, the correct perspective here is that you need to understand that, again, criminal liability will not be incurred by these individuals by the same reason that they do not possess the mental capacity to appreciate the conduct of their action. Second, a person who is under 15 years of age. Under 15 years, the reason of the law is that previously 9 years old niya siya and below. It was increased to 15 by reason na we protect the interests of the child and all the rationale involved there. So, below 15 years old or under 15 years old, they do not incur criminal liability into such. The exception is that on number 3, when you are over 15 but you're under 18, you can incur criminal liability if you acted with discernment. Meaning to say, the discernment would be one where he has full appreciation of the consequences of his action. Mugin na din example, children that are below 18 and over 15, naghabuyan na bato, and sang ginahaboy niyang bato, gapamuyayaw pa siya, and gasinggit pa siya sang words niya, mapatay ka na tani, way ka na pulos, ari mo, balusan na ka. That is a manifestation that one is discerning his action to be an unlawful exercise. Yeah, I mean, it's a wrongful conduct, I mean. So, in its part, when one is to be considered as falling under the third category, you go to Article 80, which is the application of your juvenile justice system wherein i-admit mo niyang bata sa isa ka reputable social institution for his reform. And so that is for instances nga wala siya discernment. Between the age of 15 to 18 lang siya, nag-commit siya felony, you apply the Article 80. Kaya amenda na siya. So any person naman, number 4, who while performing a lawful act with due care causes an injury by mere accident without fault or intention of doing it, then you are justified, not necessarily justified, you are exempted. Let's use the word of law. You are exempted from incurring criminal liability. Why? Because again, in relation to the justifying circumstance, what you are performing is unlawful, is a lawful act. You did it with due care. You did the act without fault or intention of causing it, but it was merely accidental. Accident is defined as one which is swayed without the control and will of any of the human intervention. So this could be one of exempting circumstance nga kung may ma-damage kamo that you present na, well, I was lawfully acting upon myself, I did not have fault or intention to cause the injury. It just so happened. So the accident would be one wherein gapang utod ka branches sa balay mo. Pagpangutod mo sa branches ng balay mo, gahalong ka, nagbutang ka kordon, kung sa diin mahulog ang imong branch, butangan mo limits out of it. And then it so happens that when that item or that branch that fell down, naigo siya and then nagligid siya going to the road and all of that, you could not have foreseen its consequence, nga maglabog siya amo na kalayo, may naigo, then you could claim that you are exempted from incurring criminal liability. But in this circumstance, under number 4, you will have to pay civil damages. Okay? Any person who act under the compulsion of an irresistible force, or one wherein he has no sense of, di ba, may elements na voluntarism, ang iyang intellect, he does not possess that, irresistible ang force. Now, that would be one of those instances wherein you are to be exempted from incurring criminal liability. Ano na yung example usually? Irresistible force found in your book would be an instance wherein threat is already being committed by you, or you're acting not on your own volition, but because of fear, maybe. The fear one is actually the 6th. Any person who acts under an impulse of an uncontrollable fear of an equal or greater injury, that is the concept where you are being prevented from imposing the, what you call this, your actions. All right, it's 2:32. May exam ta ka mo sa Thursday. Ano gani nga na-discuss ta? Sorry I am very forgetting.
May exam kami sa Thursday.
So subong supposed to be aton nga, what do you call this? 2 hours?
Yes, attorney, 2 hour ka discussion.
Okay. Sige. All right, sige. I'll continue. Here is it. Wait, where is it? Here. The 7th one is any person who fails to perform an act required by law when prevented from some insuperable cost. Now, sa exempting pa lang niya, under imbecility or insanity, there is this development. An imbecile is one who is what you considered as in an advanced age. Say, for instance, you're already in your 40s, 50s, or just age of majority. And then it so happens that his mental development is akin to a child of 2 to 7 years old. So he might be an imbecile. The other one, to constitute what we consider as insanity, there has to be the complete deprivation of intelligence. Complete deprivation of intelligence, meaning there is no freedom of will, or in the sense, one is acting without completely understanding or without the use of his own ng voluntariness na part. Ang aton niya na di nga consider is that sometimes ang mga buang may ara silang moments of clarity. And their moments of clarity is called a lucid interval. Okay? So in a lucid interval, you will treat an insane individual as if he is a normal individual. Okay? So there are issues here like epilepsy. Tao nga gakirig na bala, epileptic, they do not have what we call control over their conduct or their will. Sonambulism, you know the one where sleepwalkers, sonambulism, or those who are sleeping and then hindi sila aware nga ano sila, may gina-perform sila, ga-sleepwalk, iban sila galuto pa sa kusina, iban paninlo, that's so creepy. Pero they are not aware of what you're doing. And may instances na malignant malaria, one who is actually suffering from severe fever, and in order for him to cause relief from that, what he did was that he eventually utilized something to prevent to ease the pain, and then in the course of it was able to injure or cause harm to another individual. So these are valid defenses under imbecility or insanity. Please take note naman niya, feeble-mindedness or pedophilia is another issue, because you are not completely deprived of your intelligence. You choose to think in a different way. So you cannot cause and say, I like to have sexual intercourse with children, therefore I am insane. No, that's not the intention of the law. The intention of the law is that the complete deprivation means you cannot process your acts and your thoughts in such a manner, speaking, it actually allows you to commit a felony. Pero here, iban, pedophilia, this is not one that is contemplated to be exempted by the law. So there is this case of People versus Rafanan, that in order that the exempting circumstance of insanity may be taken into account, it is necessary that there is a complete deprivation of the intelligence. So you are deprived of reason. There is no responsibility over your own acts. You cannot, or without, or completely no discernment. You cannot identify anything or otherwise do anything. So complete absence of even your willpower to discern or to act according to prevent something or to do something, then that is what we would consider as insanity here. Okay, that is one that is contemplated by the law. There's actually a test, the test of cognition. The test of cognition, again, is the complete deprivation of your intelligence in committing a criminal act. You are prevented from contemplating that act. There's also a test of volition, or that was in a total deprivation of your free will. Cognition is the ability to think, to process mental thoughts and actions, whereas in test of volition, the ability to actually do and exercise an act. Okay? So, but our case law shows what? We rely on the cognitive one. And actually, ginasynonymous na nila kisa on the test of the free will. But ang test of free will is usually found under mitigating circumstance under Article 13, paragraph 9. Later, there is a provision for that. Schizophrenia, pleaded by the appellant, has been described as a chronic mental disorder characterized by his inability to distinguish fantasy and reality. So, and often accompanied by certain hallucinations and delusions. In the previous cases where schizophrenia was interposed as an exempting circumstance, it has been mostly rejected by our court. In a particular case, the evidence presented tended to show that if it was impairment lang of the mental faculties, such impairment is categorized to be not complete. So the keyword is complete deprivation of your mental faculties. Okay? Or complete deprivation of your intelligence. In schizophrenia, there is still the existence of your mental faculties, only that it is been impaired. Okay? So makita nyo na ang mga tao lang Crispin, Basilio, tapos they come at very instance nga brandishing knives and all. That is what we would consider as not not the contemplation of insanity. Ang instances naman niya, kita ka muna daw may nag-amok. Recently, have you seen that news clip? Nga may ara nga ano niya siya tawag? Ging arrest. I think doing ano ko say, na-share ko na. Wala lang di galing. Arab lang nag-amok, usually sa Manila, do amugin na lang manan mo, nga gapang lagas, bla may bolo and all. They cannot claim that they are insane because they have complete faculty, mental faculty. So, ang next na question, parehas to blood attorney, what if may buang gapang haboy sa, again, you categorize the buang. If the buang is, if the buang is completely, should we say, may harap man levels may harap buang, hindi siya kabalo sa ginahimo niya. Ang example sinada is that may buang nga gakot-kot. Just so happens nga gakalot siya, he's throwing away rocks far from what he's and then may gakaigo ang mga salakyan out of it. Then that would be one concrete example that one, he or she is actually deprived of his will because may compulsion to like dig and all, man, can be. Pero could you claim in saying deprived siya of his intelligence? That medical reports would be the one that would support and sustain that. All right, minority. Minority. The age of absolute criminal irresponsibility is from the age of 9 to 15. Raised from 9 to 15. That's what I was mentioning a while ago. So una, we were asked a child which is grade 1 or by at that time 7 years old took a knife and stabbed his father in the back. The father died. The question is, what crime was did the child commit? Is it parricide or homicide? Okay, so everybody argued parricide kay tatay niya, homicide kay hindi aware ang bata nga tatay niya na or sinuna siya. And the real answer is actually he did not commit anything, because the absolute rule of not incurring criminal liability is as if there is no crime that was committed. By the reason that the tenderness of the child, you cannot apply the rules, the legal rules in the same context that the child understands the rules. May it be from the point of view of the child, he's just playing, or is not aware that doing so would result into death. So that would be one of those challenges. So a child above 15 naman niya, without discernment, will be exempted. Above 15, below 18, without discernment, exempted. The periods of criminal responsibility here, 15 years old and below, conditional, 15 years old and 1 day to 18 years, full responsibility, 18 years old to 70 years old. Mitigated. The mitigated responsibility is the one wherein person is exercising discernment. So there can be criminal liability if one is acted with discernment, but you will be then referred to the application of Article 80 of the Revised Penal Code, wherein i-confine mo ni sila sa mga bahay pag-asa, youth centers, and some other institutions that does development and formation work. So the child in conflict of the law is one at the time the commission of the offense is below 18, but less than what? 18 years old and 1 day. So kamo mga 18 years old na kamo yan, no? So either you play as imbeciles or you play as insane so that you would be exempted. Okay? Now, the definition of discernment means the capacity of the child at the time of the commission of the offense to understand the differences between right and wrong, and to know what is the consequences of his wrongful act. Okay? This is a very keen example I've been telling you. Rin sa una, ginapasa na siya nga kung ang bata manghaboy, may ihaboy, tapos may gina-actor nga words, na may dala pa pamuyayaw, then the child understands the consequence. Yes? Question? Wala na. Wala. I thought someone was raising his hand. Okay. So, discernment may be shown by the manner of how the crime was being committed or the conduct of the offender after its commission. So, that example I gave you wherein the child threw a particular stone, and then in throwing it, he eventually uttered words while he was doing it. Or in the conduct of the offender, say for instance, bata pa lang, maging tiro ng sulpak, may naiguan siya. Pag tiro niya, naiguan ng iyang victim, ging palapitan niya, kaging tindakan niya pagid. So in the essence, he is doing really an awareness of a wrongful act on his part. Accident. So accident, again, the definition is very straightforward. Something that happens outside the sway of our will, or human intervention, or human will. Okay? Although it comes about through some act or will of something that is beyond our control. It lies beyond the bounds of humanly foreseeable consequences. An accident, again, is one which no human intervention supposed to be can attribute it. So maybe by the reason of the blowing of the wind, the use of the animal, o may mga ano na hindi siya purposely being drawn out, then that can be an accident per se. So in exempting circumstance, what we are exempting are individuals by reason that they lack the intention to commit something which is wrong. Okay? And intrinsically, this is contradictory to negligence. Because they have no mental faculty, no intelligence, no will, they cannot even be considered negligent because they cannot process the value of diligence. Kumbaga. So the following requisites must concur that here in an accident, we're talking about the accident. It is something that is, again, without human will or human intervention, or kumbaga, it's beyond the sway of man. Now, the accused is performing a lawful act. That performance must be made with due care. So it erases the existence of negligence because you are exercising it with due care. The injury is caused by accident. Okay? The accident, or again, it happened because, well, again, it just simply happened. Na wala man na nag-cause, wala man may isang logical consequence of it, and then that there is no fault or intent on the part of the party using or utilizing it. This is where we can also use the term damnum absque injuria, damage without injury. You can cause damage to someone, but you cannot be held civilly liable by reason that it is pure accident in its face. Irresistible force. There must be an irresistible force to reduce the actor to a mere instrument. So, say for that you were inside the bank, and within the bank came in bank robbers. They pointed the gun to you, telling you, get the money from the cashier's vault. You were doing it. because you were following the directive, you were following the instruction, you reduced yourself as an individual to be a tool, because there's an irresistible force. That force is through the employment of the bank robber hurting you or pulling the trigger so that, well, you could die eventually. So that is one of the due considerations there. Next is the uncontrollable fear. This presupposes that the person is compelled to commit a crime by another, but the compulsion is by means of intimidation or threat, not force or violence. Here, the distinction of uncontrollable fear is that it is born in the mind of the individual, making it the irresistible force. Okay? Making it, in a way, the fear in his mind. So, ginayus niya lang is ang threat or the intimidation lang. Sige, patsyonta ka. The irresistible force, in the distinction of the other one, is that there is already that physical application to you. That you would be bombarded, that in all doing that, you get to be injured. So there's that big distinction. Duress. Duress as a valid defense should be based on real, imminent, and reasonable fear for that one life or limb should not be speculated or remotely different. Okay? You're under duress. If you would review the instances wherein kung ginapakasal ka, may shotgun, uncontrollable fear. Pero kung gingbugbog ka na, nga ara ka to, irresistible force na siya. Okay? Duress, again, the valid defense here should be based on real, eminent, and reasonable fear, one occupying within yourself. All right. Here, the charts are here. Contemplation. The compulsion must be of such character to leave no opportunity to the accused to escape or self-defense in equal combat. So, it's actually, this is a new development because previously wala man siya gina-consider nga ang imo bilang the intimidation that is being given to you because of the uncontrollable fear just simply exist. Here, the criteria is that you ought to repel that fear. So in this instance, you may not be able to escape or even employ self-defense. Because actually, the self-defense is only an option for you. So that would be the criteria there. Insuperable cause. So a confessant reveals to a priest that his plan to rebel against the government. And under 116, it is required that anyone who knows such conspiracy must report to the authorities. However, due to the penitent and priest privilege communication, the priest cannot be compelled to report such information. The act of reporting, although is required under the law, the priest fails to do so. His failure was due to a lawful cause or a privilege recognized between him and the penitent. Then that would be your example for insuperable cause. Same that when lawyers are being compelled to reveal whether their clients are guilty, we have with us attorney-client privilege communication, which we cannot divulge. And if we are being compelled to do so, that's an insuperable cause. It will cost us our license. It will cost us a violation of our oath. Therefore, we are deemed exempted from incurring that liability. So, justifying exempting circumstance, self-defense. Civil liability, wala. If not complete, then it's only a mitigating circumstance. Existence, Unlawful aggression dapat aratanan, reasonable necessity, lack of sufficient provocation on the part of the person defending himself. Defense of relative, may civil liability? Wala. Kung incomplete, mitigating circumstance siya. Highlighted, unlawful aggression is a condition sine qua non. Other things, comparative, here. Defense of a stranger, still unlawful aggression. The last one is the person defending himself is not induced or motivated by revenge, resentment, or some other evil motive. The next one, avoidance of a greater evil or the state of necessity. There is civil liability. The requisites that the evil sought to be avoided actually exist. Injury feared be greater than that done to avoid it. So there's the disparity of it. There are no other practical or less harmful means of preventing it. And the fulfillment of a duty or a lawful order, no civil liability for obedience of a lawful order. But please take note of the requisites ginani nila. An order for an obedience to a lawful order requires that the order must be issued by the superior, that such order is a lawful purpose, and that the means used is also lawful. Sa fulfillment of the duty, please take note, accused acting in the performance of a duty. Whether he is acting in the performance of the duty, he is exercising the right or the position of his office, he is justified in that manner of speaking, fulfillment of a duty. So long as there is what we consider that the injury caused here is necessary consequence of a performance of a duty. Say for instance, you have a court order for the demolition of squatters. And by in doing so, what you happen to have is actually the context that you are enforcing the court order. And in enforcing the court order, you happen to injure someone. Then the injury that you caused will not create criminal liability to you simply because you are fulfilling a lawful duty. Okay? Sa exempting na naman. Exempting. Please take note, all of this, you will acquire civil liability except for accident. So an imbecile, exempt. Kung incomplete ang ining mga requisites, mitigating lang. Insane is only exempt if he acted not during a lucid interval. Minority, you've seen that. 15 and below, absolutely exempt, conditionally exempt. So exempt only applies if shown that the minor acted without discernment. The moment that there is discernment, then you can claim what? A conditional or a mitigating liability. Person performing a lawful duty, you will not incur what? You will not incur civil liability for that accident because you're performing a lawful act. There is no negligence because you're acting with due care. You caused injury through the accident, and again, without fault or your intention. No civil liability, no criminal liability because that was an accident. Compulsion of an irresistible force, again, compulsion by means of physical force. Na, diha? Such more should be irresistible. You cannot resist it. Is there such a thing if it is incomplete, mitigating siya? No. If it is incomplete, you will have criminal liability here. Impulsive and uncontrollable fear, here, you will incur civil liability, and the threat must be here. The causes of fear is an evil greater than that what you intended. Okay. Mitigating. What's the effect of mitigating circumstance? In mitigating circumstances, usually because your exempting and justifying are incomplete or there is a loophole, generally, instead of giving you scot-free or no liability at all, you will still have liability, but we will lessen, discounted kumbaga ang penalty mo. So incomplete defense, those mentioned in the preceding chapter, when all the requisites to justify the exempt are actually not attendant or incomplete. The mitigating responsibility here, an example, under 18 years of age and over 70, praeter intentionem, the one that we've mentioned under Article 3, that the offender has no intention to commit so grave a wrong as that being committed. So mitigating circumstance, as I mentioned to you, together with aberratio ictus, error and ponsone, praeter intentionem is a mitigating circumstance. But again, you are still confronted with incurring criminal liability, because the provision actually states, although the wrongful act done be different from that you have intended. So you did not intend to kill someone. Ang intention mo lang niya is actually to hurt them. But eventually, it causes their death. And you cannot claim that, again, as a defense. It's not among the justifying circumstance. Because the prior act is already a wrongful act. Notice nyo, sa exempting, kag sa justifying circumstance, the act must be considered as lawful or an exercise of a lawful right or a lawful office. The moment that you're exercising a wrongful act, the consequence of that wrongful act will be a burden for you to incur the criminal liability that we're speaking of. Provocation. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Meaning to say, in this instance, incomplete na self-defense kaya you've been providing for the provocation. Provocation, again, is an instance wherein you cause an offense, you instigate, or in a way, insult, or parang ging provoke ka. Ang sa term yun na day sa inyong generation, di ba, triggered? I'm triggered. You triggered me. So in instances, you must not be the cause of such. So immediate vindication of a grave offense, that is the act that be committed immediately, vindication of a grave offense. Medyo damo ni ang mitigating, though 10, yes. Actually, it's not just, it's more than 10. Okay, there's analogous circumstance. Passion and or obfuscation. That you have acted upon an impulse of a powerful or naturally to have produced passion or obfuscation. Passion, here, in contrast with exempting circumstance, there is only an impairment of your mental faculties or your intelligence. That's why mitigating siya, hindi siya exempting. You're acting based on impulse. Amo ni siyang iban bala nga mahambal nga nagdilim ang aking paningin. Bo, maghambal ka sa muna passion and obfuscation in adayon. Meaning you were motivated to do some other act. And in so doing, you do not qualify to be entertained part of exempting circumstance. Okay? Voluntary surrender. So in instances wherein you actually committed it, you killed someone without the use of justifying circumstance or being under the category of exempted individuals, you just simply killed someone, but immediately you acknowledge your fault, you acknowledge that you indeed have committed a wrongful act, then by in itself you will be awarded as a mitigating circumstance of volunteer. So you volunteered, wala mo naging pabudlayan ang gobyerno, palapit ka na lang. Good. Included within it is the plea of being guilty. You acknowledge that you have indeed committed a wrong, and then in doing so, you will be confronted with a lesser penalty. So i-mitigate, i-discount ang iyong mga penalty. Here, the context of deaf, dumb, and blind, that the offender is deaf, dumb, and blind, or otherwise suffering from a physical defect which thus restricts his means of action, defense, and communication with his fellow beings. So, for instances, the offender is the one who is deaf and dumb or suffering from physical defect. But ang logic sinadi is that the law understands that due to your limitations, you will be discounted with your penalty. Illness, such illness of the offender that would diminish the exercise of the willpower. So here, this is where the contrast again from exempting circumstance, that there's a complete deprivation. In here, there's only a diminishing, or it's an incomplete deprivation. You've been deprived but temporarily, or it only diminished or lessened your capacity for restraining yourself or to the use of your intellect, then you will be held criminally liable, but lesser ang penalty by reason of the illness. And such analogous or any other circumstance which is similar to the above mentioned. I need you to understand the very fundamentals of mitigating circumstances, whether they are privileged or ordinary. Okay? In ordinary or generic mitigating circumstance, what is the purpose? It can be offset by an aggravating circumstance. So duly acknowledge that in one scenario, there can be aggravating circumstance and there can be mitigating circumstance. So the default rule is that if you fall under the mitigating circumstance, you will be granted what? Discount to the penalty. However, kung ang mitigating circumstance is categorized as an ordinary or generic mitigating circumstance, okay? And then there is an existence of an aggravating circumstance, offset. Wala. Bawi lang. Nothing. There will be as if you will incur the normal penalty under the law. So, if it is not offset naman, meaning it produces the effect of applying the penalty only to the minimum period. Siguro I would assign your assignment as to know what are the different scales of penalty. What are the different scales of penalty so that you would understand the minimum period, the medium period, and the maximum period. Okay? So privilege naman yung mitigating. Here, it's more of a higher trump card, kumbaga. Why? Because it lowers down the degree of the penalty that is going to be provided to you. It lowers down the penalty of what you will be incurring. Okay? Here are some of the examples of privilege mitigating circumstance. Wait. When the offender is a minor, or in such case falls under the Juvenile Justice Welfare Act, it's considered as a privilege mitigating. You can lower the degree of the penalty. If it falls under the requisites of the exempting and justifying circumstance that are present, and majority of the requisites are there, but not all, privilege siya. What if there are ordinary mitigating circumstances, 2 or more, but no aggravating? So 2 plus 1. 2 equals 1 gali, sorry. So ma-evolve siya nga ang mitigating mo nga circumstance would be now a privilege mitigating circumstance. It now allows you to what? Lower down to 1 degree or 2 degrees of your penalty. Voluntary release of persons illegally detained within 3 days. So instances wherein a person was escaped and then he stayed there. So wala siya lagyo, then you can be considered as one where, well, privileged siya. Abandonment without justification of spouse or committed adultery, then it's also one of those instances wherein privilege ang nature allows you to lower the penalty to 2 or more degrees. When all of the requisites necessary to justify the act is exempt from criminal liability are not attendant, then you would be here considered as what? Incomplete self-defense. The only instance it becomes a privilege mitigating is when the majority of the requisites of self-defense or defense of the relatives are present. Meaning to say, the court did not appreciate that there is unlawful aggression, but you employed the reasonable necessity, and at the same time, you did not provoke the individual. Therefore, you can be given a privilege mitigating circumstance. And then 5, praeter intentionem, it is the intention of the offender at that moment when he is committing at the time he is what? Being delivered or considered. Okay. I'd like to share to you the point of to understand the scales of penalty. You need to go to Article 25. Wait, Article 25 ba? Oh yeah. Sige, 15 minutes, dasig na lang. 10 minutes or less. Let me just show you the... What page? Have you gone through that page? Wait. Because we're gonna look into the penalties so that you would be able to aware. 25. Question? Yeah. Here. 25. Okay. Go ahead. I'm still
Attorney,
searching.
pwede ka time out na 2 minutes kaya gina-observe na mo ng gina-lesson mo, attorney.
Sige, go. 2 minutes. Go. 2 minutes. Alright, sige. I need you to understand the table in front of you. So these are the divisible penalties. First, wait, this one. Pen. So if you're going to look at this, these are the penalties that we have under the law. You can have arresto menor, mayor, prisión correccional, prisión mayor, reclusión temporal. There should be reclusión perpetua, but it's already been suspended. So this is the duration. What is included in the penalty? Are you listening?
Yes, attorney.
All right.
Yes, attorney.
So when you're talking about reclusion temporal, it's from 12 years, 1 day to 20 years. But let's go to the bottom lang siguro na. So may mga felonies that it indicates what is the duration of the imprisonment. So arresto menor from 1 day to 30 days. 1 day to 30 days. And here you would look into the periods, minimum, medium, maximum. Ang arresto minor is divided into 3. From 1 to 10 days nga mapriso ka, it's under minimum period. From medium naman niya, 11 days to 20 days, that's the content of the medium period that you can sustain the imprisonment. And then on the maximum period, 21 days to 30 days ang posible nga mapriso ka if you get arresto menor. So when you're talking about the penalty under arresto menor, it's 1 day to 30 days. And if you're being asked what are the different periods for that, this is what we're talking about when we were discussing mitigating circumstance. Kung mitigating circumstance ka, ang i-apply sa imo is the ordinary sense minimum period. But what about the degrees, attorney? When we're talking about privilege mitigating, say for instance, the penalty that is imposed to you under the law falls under prisión mayor. Prisión mayor carries with it 6 years, 1 day to 12 years. 6 years, 1 day, 6, 1, 12. 6, 1, 12 na siya usually. 6, 1, 12. And in so doing, because you have a privilege mitigating by reason of, say for instance, an example there is minority. Minority will now give you 1 degree lower. You're counting penalties to the degree. This is 1 degree, 1 degree, 1 degree, 1 degree, and 1 degree. Now, the privilege mitigating rule is that it allows you to lower down the penalty to 1 degree lower or 2 or more, depende kung the existence of the privileges. Say for instance, no attending aggravating circumstance and then damo kaya incomplete nga mga justifying or there are 2 or more mitigating circumstance and then there is no aggravating circumstance, then possible that you can still lower the degree in this level. Okay, when we're talking of degrees, we're talking about the penalties in their scale. Okay, this is for 1 degree, another degree, and this degree. Right. When we're talking about periods, we're talking about the divisibility of the penalty. A penalty can be divided into 3, minimum, medium, and then maximum. So just be familiar first with the range of the penalty. Say for instance, what do you call this? The arresto mayor. From 1 month to 1 day to, pila ni siya? 6 months. From 1 month, 1 day to 6 months. That is the range of arresto mayor. If prisión correccional is to be imposed under the law, your entirety of computing and understanding prison correctional will be from 6 months, 1 day to 6 years. 616. Prison mayor, which is the higher form of penalty, usually the classification of other penalties would be for falling under prison mayor. 6 years, 1 day to 12 years. 6 years, 1 day to 12 years. And then reclusion temporal, 12 years, 1 day to 20 years. Reclusion perpetua, 20 years, 1 day until 40 years na siya. But it's not included anymore. Reclusion temporal and reclusion perpetua. The higher form is reclusion perpetua. Reclusion perpetua. Now, in different periods, you have the minimum, maximum, medium periods. It's just simply dividing the entirety of the penalty to several dates, months. Tapos lang na siya because kung ikaw ang ging priso, tapos you would appreciate that you do not have aggravating circumstance and you only have mitigating circumstance, the thing is that you will be given the minor period. You will enjoy it. The penalty will be in between 6 months to 2 years, 4 months. This is not mentioning the ISLAW or indeterminate sentence law. Okay, may instances that the court will issue you within this group, the court will just simply say, okay, you are hereby sentenced to 1 year and 6 months. That's still within the frame of 6 months to 2 years and 4 months. Okay? So the appreciation of mitigating circumstance is that in instances, it lowers the degree. And if there are no aggravating circumstance that will offset it, you can prefer to have the period with you. Okay? So imagine there are other instances, I have cases wherein rigid ang gina-maximize nila because kulang pa gani ang mitigating because tanan aggravating ging pangbutang. So medyo, well, that's traumatic also on their part. Nonetheless, that's the content for understanding your penalties. You need to absorb that penalty first. Okay? Sige. Next week, we'll meet and I'll just announce some of the works you can do independently. And then recitation covering na lang the ones that we've not discussed. So aggravating, alternative, what else pa? Amo naman lang na aggravating and alternative circumstance. Okay? So dira na yata na this nga recitation for you. No, para do hindi man bugat sa inyo. Any questions?
Attorney, question. Where will we see the video? Some modules yapon or you will send it to someone?
Wait, modules. For all of these videos, I'll post it sa module yun para makita nyo. Wala ko pa na-upload tanan yung mga recording ta. So for instance, the previous ones. All right?
Attorney.
Okay. So if you have any questions, you can message me or any concerns, just do so. Good luck on your exams, on your other subjects, and please continue to practice minimum health protocol. Maximum, not just minimum health protocol. Maximize vigilance. Live Jesus in our hearts.
Forever.
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 You can go.
Thank you, goodbye, attorney.
Thank you,
attorney.
Ba? Kapoy.
Attorney.
Yes, Hannah.
Attorney, nag-aasa mo ba na classmates kung ma-upload mo kano ang handouts mo gin-show kay
I'll do it
Gina.
now. Sige, you wait. I'll do it now.
Attorney.
Okay.
And attorney, Ben, baliway naka-attend kay brownout subong
Sige lang.
most of the
Bawi
areas
sila sa video.
Thank you, attorney.
Thank you, good. Keep safe.